That's a remarkable turnout, given the fact that it's a World Cup football match on. I think it's quite amazing. I didn't realise there had been that number of football refugees in Leicester. But anyway, back in June, I drafted this press release to be issued on behalf of the Secular Society about the human rights bill, which at that time was looming. And we had a number of concerns, particularly as how they affected the rights of the non-religious. But of course, with the advent of the short-lived Truss government and the change in prime ministers, it's fallen off the parliamentary timetable, it would seem, but it looks like it's coming back on. And really, I'm hoping at the end of this talk tonight, I'll see what alterations I need to make to this press release, what else I need to put in it, and what else I need to take out. So I'm really looking forward to the contents of this, and I hope we don't have to send it at all. I hope it's a wonderful bill, but I somehow doubt it. So can I introduce, is it Professor Alwyn or Alwyn Jones?
Hi there.
Oh, right, okay.
I think he is originally... Wonderful to see everybody. I hope everybody can hear all right. Obviously I'm using a microphone, so hopefully that will reach everybody. But if you can't hear, please let me know. I think the sound can be turned up, or I can try to project more. As you've just heard, I'm Alwyn Jones, and our subject for tonight's talk is what may be the removal of human rights through a Bill of Rights bill, a proposal currently before Parliament, and as you just heard, something that was temporarily withdrawn during the short-lived government of Liz Truss, but which has returned, it seems, under the current Prime Minister, and that seems to be linked to the fact that early this summer, when this particular Bill of Rights was originally proposed, the proposal came from the then Justice Secretary, Dominic Raab. And under the government of Rishi Sunak, he has been reappointed as Justice Secretary. So it seems that the return of the same minister to be in charge of the legal system has led to the return of a bill which, he says, will reinforce human rights protection in the UK. So it will be interesting to see people's view on that, and to consider with you this evening what effects the bill would have if it was passed. If you're interested in the progress of the bill, if you simply search online for UK Parliament Bill of Rights, you can find a web page, part of which will look like this green part on the left. And for a few weeks now, it's showing as this bill only having reached the second reading stage in the House of Commons. So it is as it were, a live proposal to change the law, but it's got a number of parliamentary stages yet to come before it will become an act. It's been criticised, as you can see in the middle part of the first slide, by human rights organisations, Amnesty International and Liberty, who took over the advertising on a couple of websites, Conservative Home and Labour List, with the image that you can see here, calling it a complete mess. And they've also argued that this is not reinforcing rights, but removing them. So that's the debate that we're investigating tonight. So this is intended to give you an idea of where we're heading, and I thought it might be useful to give you a bit of a tour of how the current law works, so that you can put what's being proposed in context to see how the proposal would affect the arrangements that we have now. So we'll look at the current law, the Human Rights Act going back to 1998, in force now for 22 years, the effects of the bill that's being proposed now, and perhaps some consideration of whether what's proposed would indeed reinforce or reduce rights. So where did the Human Rights Act that we have now come from? And how does it work currently? I've got a quick illustration of two cases involving privacy. One before the Human Rights Act, and one after. My main memory of the actor Gordon Kay was from his 1980s television series Allo Allo. I don't know if people are familiar with that. Rather dated, I think it would be fair to say today, but popular at the time. Unfortunately, before the time of this case, he had been in a serious accident. A large piece of wood had, presumably part of a tree, had fallen during a storm when he was driving and crashed through his windscreen, causing him a serious head injury. He was in hospital. He didn't really know what was going on. When two journalists from, well, think about whether you call them journalists, from the Sunday Sport entered his room, ignoring a notice that had been put up indicating that he was not accepting any visitors, and they conducted what they called an interview with him and took photos and proposed to publish this. Gordon Kay's agent, acting on his behalf, went to court in Kay and Robertson and asked the court to stop the publication of this interview. And this is what Lord Justice Bingham said in his judgment. You can see that he was sympathetic for the vulnerability of somebody in a hospital bed with a serious head injury, a vulnerable person. But there was a problem. And the problem was in the nature of how the law operated before the Human Rights Act. Before the Human Rights Act, there was a general principle of liberty. Well, liberty is an appealing thing. We like to be able to live as we wish. But if I have liberty and so does everybody else, then there may be no constraints, no protections on the rights of the vulnerable. So Mr. Kay had liberty, he was free to do anything that the law didn't prohibit, but the journalists were also free under the law at the time to invade his privacy. And before the Human Rights Act, there was no legally enforceable right to privacy in this jurisdiction. Even though, as you can see, the judge was sympathetic to his situation. Fast forward to after the Human Rights Act and the wedding of two other actors. So we've got two privacy cases involving people who were famous at the time. Michael Douglas and Catherine Zeta-Jones got married. And they did a deal with OK magazine for photos of their wedding to be published. So that was with their permission. But somehow, someone acting for the OK magazine's rival, Hello magazine, was able to get pictures of the wedding as well. And Hello magazine proposed to publish their pictures from the wedding, taken without permission and in clear breach of what the couple had wished. Now, since the Human Rights Act had come into force, there was a legally enforceable right to privacy. Although, of course, as you might imagine, a right to privacy must be balanced against other rights, such as freedom of expression. And in fact, the court was not willing to order that the photos could not be published, particularly in the context of the sort of history of this case, that there had been a whole series of celebrity weddings in which either OK Magazine or Hello Magazine have been able to negotiate with the celebrity couple involved to have the rights to publish photos from the wedding, and whichever magazine did not obtain those rights would then try to obtain the photos by other means. And so there'd been a history of this kind of activity. And so in effect it seems that while this case certainly did involve their privacy, on one level it was about the competition between two celebrity gossip magazines to publish photos. But this simply illustrates the role that the Human Rights Act played in establishing not just a sort of general principle of liberty that we're free to act as we wish unless prohibited by law, but that we should have certain rights. To understand fully why the Human Rights Act was created, it may be worth looking at what the people who wrote it thought they were achieving. And this may be relevant particularly if the Human Rights Act is repealed, as the government proposes to do, and replace it with something else. So firstly, before the Human Rights Act was passed in 1998, as you may know, if our rights were violated, it didn't mean that there was nothing that we could do, because we could attempt to enforce our rights in the courts in this country, and if that was not successful, you may well know the name of the court that people could go to, and still can, if our rights are not protected here. The European Court of Human Rights in Strasbourg in France, an institution, as you may know, of an international organisation called the Council of Europe. So even though the United Kingdom is no longer a member of the European Union, we remain members of the Council of Europe, and it's still possible to take a case to the European Court of Human Rights. So why do we need a Human Rights Act? Well, one reason is simply that hundreds of millions of people have that same right to take cases to the European Court of Human Rights. Until recently, until Russia withdrew from its membership after its invasion of Ukraine, people from Russia to Spain and all across, certainly including all EU member states, were able to take cases to the European Court of Human Rights. And the result was an enormous queue. It would take years, on average at the time that the Human Rights Act was passed, a 5-year delay for your case to be heard. You've probably heard the expression, justice delayed is justice denied. And so the idea was that rather than having to wait 5 years for the European Court of Human Rights judges to even start to look at our treatment if we were treated improperly by the state, that we could enforce our rights in the courts in this country. And the idea was that the Human Rights Act would increase the influence of human rights protection in the UK courts, and that there would be a sort of international dialogue. So courts in the UK would be able to apply human rights to new situations. So of course at the time of the Human Rights Act, new developments such as the internet and mobile phone technology and so on, created new issues relating to issues such as privacy that the courts would need to consider. And the idea was that British judges would be able to have a voice about the interpretation of these rights. So how does the Human Rights Act work now that we currently have it? Well, the key words here, I'm conscious that this will be a lot of words thrown at you, so apologies for the volume of words you'll be receiving this evening. The key words I suggest in this part of the Human Rights Act are simply 3 words. Take into account. What's the significance of those 3 words? Well, if I was a lawyer and you were a judge in court, and if I was referring you to a decision of the European Court of Human Rights, Obviously, once the Human Rights Act was in force, you would need to know, if you were a judge in this jurisdiction, what to do with that. Do you treat it as something that, as an instruction that you must obey? Or do you treat it more as, well, somebody's opinion that you will consider, but not necessarily agree with? The Human Rights Act takes the second view. The decisions of the European Court of Human Rights are not orders. They're expert views on human rights protection. British courts are not required to follow them. I mentioned a couple of minutes ago that an important part of the idea of establishing the law that we have now, the Human Rights Act 1998, was to increase the influence of human rights in UK law. How would that be done? Well, something that people spend a lot of time, where I teach in law school, debating is the meaning of words, the meaning of words in legislation. And a lot of appeal cases are, in the end, debates about the understanding of what was the purpose of that rule, what was trying to be achieved. And as part of that decision-making process, under the current law, judges must try to adopt an interpretation of the law that protects human rights rather than violating it. And the key phrase here, I suggest, as far as is possible. And you might well be thinking, as I did when I first read that phrase, when's that? When is it possible to adopt an interpretation of words to avoid a breach of human rights? Let's look at an example, because this may be all sounding rather abstract and remote from people's experience. In Guidon against Godin Mendoza, there was a gay couple who lived together. One of them had a particular kind of tenancy, a rent act tenancy. A useful thing to have, as you may know if you rented a home during that time before the deregulation of private rented tenancies under the Housing Act of 1988. The days of security for tenants, the days of being able to ask for a fair rent to be established, and so on. Very different time. So this was a very attractive tenancy to have, and sadly, when the tenant died, his partner wanted to inherit that valuable tenancy. But there was a problem. The Rent Act 1977 said that to inherit that specific tenancy, you had to be the spouse of the tenant. And although the Civil Partnerships Act was coming into force at the time of the case, when the facts of the case that the case was based on occurred, civil partnerships or same-sex marriage were not yet available in English law. So if spouse was interpreted according to its traditional meaning, it would be legally impossible for the surviving partner to inherit his partner's tenancy, even though a married couple would have been able to pass on the tenancy. So what did the judges do? They applied Section 3 of the Human Rights Act. They said, well, clearly this law discriminates against same-sex couples on the basis of their sexual orientation. So we have a human rights issue here. Therefore, if it's possible to do so, we should interpret the law in a way that protects the human right. And by a 4-to-1 majority, the judges said that they could, it was possible, to interpret the word spouse in this context to mean living together as husband and wife, or as if you were husband and wife. And so the judges used their Section 3 power under the Human Rights Act to deal with the discrimination without needing to wait for Parliament to change the law. So that was a difference that the Human Rights Act made. And I've mentioned that judges must, whenever possible, interpret the law in a way that protects human rights. But what if it isn't possible? What if a law very clearly establishes, for example, detention without trial? I don't think that could be interpreted as compatible with human rights. Well, under Section 4 of the Human Rights Act, judges have a power to formally declare that they are unable to interpret a British law in a way that protects human rights. They can make a declaration of incompatibility. But it's worth noting in passing that the Human Rights Act does not work in a way that we might expect a human rights law to work. Just highlighting that little phrase there at the bottom. A declaration of incompatibility does not affect the validity, operation or enforcement of the law that it's in relation to. Take an example. I was mentioning a moment ago the idea of a law allowing for detention without trial. You may or may not know there has been such a law in the UK after the horrific terrorist attacks on September the 11th, 2001. You might have heard at the time that the United States lawmakers passed emergency legislation, and so did Parliament here. They passed the Anti-Terror Security and Crime Act 2001. And that 2001 Act, among other things, allowed for the detention without trial of suspected terrorists. Detention without trial. That doesn't protect human rights. So what happens when somebody who's detained in Belmarsh Maximum Security Prison goes to court and says, my rights are violated, and the judges say, well, yes they are, and we declare that this law does not protect human rights. We cannot interpret it in a way that avoids the violation. Where would the detainees be the day after they've won their case, as they did, and got a Section 4 declaration under the Human Rights Act? Would they be celebrating with their families? Would they be in a TV studio talking about the experience of being picked up by the police and told, we're taking you to prison? No, we're not telling you why. No, you won't get a trial, and we can't tell you how long you'll be there for. Where were they? Does not affect the continuing operation of the law. They were still in prison. Because the Human Rights Act under Section 4 defers to Parliament a lot of the time. So it was for Parliament, not the judges, to address this issue. If the judges are not able to find an interpretation of the law that protects human rights, all the judges can do is to formally indicate that they're saying there's a problem and hand the mess back to Parliament. So that may be seen as a problem potentially for the Human Rights Act. Maybe it's something that the Bill of Rights might fix, we'll see. However, there have been people such as the Joint Committee on Human Rights, a committee of the House of Commons and House of Lords, who've defended that position, which may seem rather strange, the idea that the judges can point to a violation of human rights, even people being detained without seeing the evidence against them in a trial, and then it being up to Parliament to change the law. What they said was, well, Parliament should be ultimately in charge of what the law says. And there could, of course, be benefits to this situation. When I follow the news about elections in the United States, people talk about the judges that the candidates would appoint. And there's been significant interest in the actions of US Supreme Court judges, such as those appointed by President Trump, with, of course, the overturning of Roe versus Wade and its effect on reproductive rights in the United States. So judges were appointed by a particular head of state, and that led to a dramatic loss of rights. And when there's an election in the UK, say in 2019, I don't see the same warnings as there are in the United States. People don't say here, oh, don't vote for that person because think about the judges they will appoint. Why not? Well, because in the UK we have an independent judicial appointments commission. So it's not a matter for Rishi Sunak or Boris Johnson or anybody else in the government who the judges should be. But if our judges had the power to strike down legislation that they said violated human rights, perhaps that would change. The Human Rights Act also says that public authorities have a duty to protect human rights, not private organisations, and that too could be seen as a shortcoming of the Human Rights Act. So, for example, if I'm a tenant, we'll turn to the example of housing, whose rights are violated by a local authority landlord, I may have protection under the Human Rights Act. But if I'm treated poorly by a private landlord, I may have no protection at all. And it's worth noting in passing too that the definition of public authority specifically excludes Parliament. Why am I noting that in passing? I'm not too worried. I don't think that Parliament is setting up some kind of horrifying dungeon of horrors underneath its buildings to carry out unspeakable actions. I suspect that this statement that Parliament is not a public authority is designed to repeat what we were saying earlier, that the Human Rights Act defers to Parliament and leaves the final say about what the law will be up to Parliament. So, we've seen how the current law operates, and we've seen some possible criticisms of it, and other criticisms have been made of the current law. It was criticised because of the changes to the UK Constitution that it made. It was criticised by people who were concerned about what they saw as foreign influence. So for me, the way that our human rights law, if you want to have one, operates relates to not just how we would like to live as a society, how we'd like our relationship to be with the government. It also relates to how we'd like our country to relate to its neighbours and others around the world. Do we want our judges and our government to be influenced by, for example, judges at the European Court of Human Rights in a sort of dialogue with human rights judges elsewhere? The Human Rights Act was criticised for preventing the removal of offenders, which on occasion it has done. So, for example, there's a principle that if somebody would face a real risk of torture in another country that the Home Office would like to remove them to, they cannot be sent there. Whether they should be removed in such a situation is something we may want to think about. And although, as I've just indicated, the Human Rights Act defers to Parliament and leaves it for Parliament to have the last word about what the law should be, there have been people who've criticised the Human Rights Act as undermining sovereignty. So, what about the Bill of Rights then? This may be what you were mainly coming to hear, so apologies if it's felt like a long time to get there. Mark Elliott, a professor at Cambridge University, wrote about this proposal when it was released, as we heard earlier, in June. And he pointed to ways in which actually the Bill of Rights would represent continuity in some ways, rather than change. I'm conscious that there's all sorts of legal jargon happening on the screen, so don't be afraid to point that out or ask at the end if you'd like to. So, for example, the ECHR, as you might have guessed, refers to the European Convention on Human Rights. And Convention rights refers to the human rights protected by that treaty, such as the right to life, freedom from torture, freedom from slavery, the right to liberty, the right to fair trial, the right of thought, conscience and religion, and so on. So the same rights would continue to exist, even under the Bill of Rights proposal that Dominic Raab would like to see. So this may be relevant to your press release. The UK would, under the Bill of Rights at least, remain as a country that promises to protect those rights. UK courts would still be able to make those formal statements that a law violates human rights, and government bodies would still be expected to protect the rights. So perhaps the human rights organisations are mistaken when they say this is a rights removal bill. There is perhaps a danger in the description of the Bill of Rights as a rights removal bill, because of course the government could simply reply in response, but we're not removing any rights because all the same rights will remain. But nevertheless, I suggest there are reasons to be concerned about the effects of the bill. In particular, remember the case of the gay couple. One was a tenant with this particularly valuable tenancy under the Rent Act. The other hoped to inherit his tenancy when he died. Because the judges under the Human Rights Act had a duty to interpret the law when possible in a way that would protect human rights, the judges were able to say that the surviving partner would inherit that tenancy. That duty and power on the judges will be removed under the Bill of Rights that's been proposed. The Bill of Rights would also say that European Court of Human Rights decisions don't affect Parliament's power to make law, and that the UK Supreme Court is the top judicial authority on convention rights in the UK. My reaction to those two statements is surprise, because that's the law now. So this makes me wonder why the government is proposing legislation that would make statements as if they were changing the law, when in fact European Court of Human Rights decisions don't constrain Parliament's power to make law. As we saw, as I mentioned earlier, the Anti-Terror Security and Crime Act 2001. After the horrifying September the 11th terrorist attacks in New York and Washington DC, the UK Parliament was able to pass a law establishing detention without trial, and the background of European Court of Human Rights decisions did not prevent that. And the UK Supreme Court is the top judicial authority. And for a bill which is advertised as reinforcing rights, the bill in fact seems to do quite a lot to limit their effect. So UK courts may not adopt new interpretations that would expand human rights principles to new areas unless they're convinced. When I say Strasbourg Court, that's a shorthand for the European Court of Human Rights, by the way, just as Downing Street is shorthand for the government or the office of the Prime Minister. The bill would say, if it became law, that the courts must give great weight to freedom of speech. Perhaps that's a way to reinforce rights. The Human Rights Act that we have now says that the courts must give particular regard to freedom of speech. Would it reinforce freedom of speech, just to replace particular regard with great weight, perhaps? Only way to know is to see what will happen. And in a couple of other ways that are worth remembering, the Bill of Rights would try to constrain, try to limit the impact of human rights, in particular in relation to positive obligations. What do I mean by a positive obligation? Well, Dominic Raab's view, if you read his book on human rights, is that human rights should be interpreted as a sort of invisible bubble around us that the state must not be allowed to penetrate, except under certain conditions. So, human rights are, on this view, instructions to the police, government agencies and so on, that you must not interfere with my privacy or my right to vote or whatever it might be. And obviously negative obligations in that sense are good things. I don't want to be physically ill-treated or detained for no good reason by the state. But negative obligations would do nothing for somebody who's cold and can't heat their home in winter. Negative obligations would do nothing for a family who are mourning the death of a family member at the hands of the police and asking for an independent investigation. Under the right to life, there's a positive obligation to independently investigate a suspicious death if, for example, somebody has died in police custody and there's a suspicion that they were not treated properly. That's an example of a positive obligation. And so if there are reports, as of course there have been, for example, of institutional racism in public authorities, or institutional misogyny or other forms of discrimination, there's a positive obligation to act. But there would not be so much in future if the courts were instructed to avoid positive obligations. So no new positive obligations, and also no human rights implications for overseas military operations. Now, this is something that the government seem to feel very strongly about. In their view, human rights have no place on the battlefield. So if British armed forces are taking part in a peacekeeping operation or a relief operation, whatever it might be, the view is taken, this has nothing to do with human rights. But from the point of view of human rights protection, the idea of human rights usually includes the idea that they protect us all the time. That the only qualifications we need to benefit from human rights are to be human. And that they will protect us from the state in any situation that we're in. And so, when in 2013, the families of British soldiers brought a human rights case because their inadequate military vehicles had not protected their family members from improvised explosive devices, they were able to make a successful claim, even though the claim involved overseas military operations. So that's an area where human rights would be limited rather than reinforced. Similarly, human rights are often, of course, used by those who are particularly vulnerable, whether because they're marginalised or excluded from society, or have very little in terms of resources, or are not citizens, or whatever it might be. Prisoners, of course, can be particularly vulnerable in different situations. The Bill of Rights would instruct the courts to give the greatest weight, whatever that means, to the need for public protection, in any case involving the rights of prisoners, and would instruct the courts to defer to Parliament on issues involving the balancing of policy with government aims and rights, and would also try to minimise the impact of a particular right on people from being deported from the UK. So, if, for example, somebody came to the UK 50 years ago as a child, and the UK is the only home that they remember, they've got a family here, and they've got very strong links with their local community, and if they commit a criminal offence which is serious, but which is, out of character and a one-off offence, currently under the UK Borders Act 2007, if they're not a UK citizen, there will be an automatic deportation, and in most cases the only possible defence against that will be a human rights argument. Now there is of course a debate to be had about the extent to which human rights should be used in these cases, but you can see the government's concern again is to limit the effect of rights rather than to reinforce them. And as I mentioned earlier, there are examples in the Bill of Rights where it seems that the bill will be stating things that already exist, such as the point that the top judges in the UK are the highest judicial authority over human rights law. And there are also criticisms, for example, from Helen Tyrrell and Conal Mallory, about the idea of how much the words like greatest weight appear in the Bill of Rights, so that judges are constantly being told they have to interpret human rights in certain ways. Also, I mentioned that when I was talking about negative and positive obligations, that negative obligations are of no use to somebody if you're waiting 40 hours for an ambulance, or if you're being evicted from your home. You need a positive obligation. But even then, the Human Rights Act that we have now offers a limited, fairly cautious range of rights, really. Very important ones, yes, right to life, freedom from torture, freedom from slavery and forced labour, very important rights. But there are a number of international human rights treaties created since the European Court of Human Rights, over 70 years ago now, establishing rights such as a right to housing. And people talk about, in the era of the awareness that we have now of climate change, should there be a right to a clean environment, for example. But although the Bill of Rights that's being proposed mentions the right to trial by jury, a right that we already have, it establishes no new rights. So that raises the question, at least, of how the government can justify its claim to be reinforcing rights, whereas we've seen, at least in my view, the Bill of Rights seems to go out of its way to limit access to rights and to instruct judges to give great weight to the government and to Parliament's interests rather than the interests and needs of vulnerable people. And so, as I mentioned, for example, the instruction to the judges to avoid positive obligations of human rights. And it's even been argued that those benefits of the Human Rights Act, such as being able to protect our rights in our courts in this country and avoid a long wait for the European Court of Human Rights, would be lost with the Bill of Rights. You may be glad to know, we've made it to the end. Thank you for being very patient. I'm conscious I've thrown a lot of words at you and a lot of jargon, so I believe there's some time to perhaps ask questions if you would like to, maybe to raise issues or concerns that you may have, or perhaps to debate whether you see the bill as one that would reinforce or remove rights, or perhaps something else. Thank you very much.